Travis Wayne Goodsell. Okay, I've finished with this second motion. And again, I remind those viewers who are coming here, I am Mormon, born and raised, 50 years. But I will not bend over and allow the church to abuse me. Do you not understand that, Mormons? The church is not the true church. Because this is not how Jesus behaves, and they need to be held accountable. If you don't like it, tough. You worship Satan. That's what it means. Go look at the inverted pentagrams all over the place. That's the symbol of Satan. That's why they are abusing us. You too. You're just taking it. I will not take it anymore, and thus the lawsuit against them. And they've lost. Alright. Here's the motion for disbarment and disciplinary action of defense counsel with prejudice. This is the reading. I've already gone over what I was going to put in this, and it's all set up, ready to be sent. I'm just going to do this video reading, make any final edits if necessary, and then proceed to email it before it gets uploaded on YouTube for you to watch. The statutes, rules that are being used in this: 18 USC 1512. That involves all kinds of tampering in a judiciary proceeding. I got to use this several times for this, and I will, I should have, I can use it in the next one for the final order of judgment as well. And also 18 USC 1956, which, as you remember from my other video, if you stayed to the full end of the hour, money laundering. See, this is not Jesus' church. Followers of Jesus, who are supposed to lead by his example, do not launder money. They do not tamper in court cases. So here we go. Argument 1. There are 3 arguments. As revealed in the plaintiff's motion to strike, 25, motion to strike, the defense counsel revealed the plaintiff's received the plaintiff's amended complaint. As revealed in the plaintiff's motion to strike, 25, motion to strike, the defense counsel also obtained an unserved copy of the plaintiff's original complaint, which was denied by Judge First, 9-minute entry, without prejudice. 3. The plaintiff refiled an amended complaint, 10, amended complaint. The 10 and the numbers that I listed, they're part of the docket numbering, in case you didn't know. 4. The defense counsel filed their motion to dismiss after the plaintiff's amended complaint was filed. 17, motion to dismiss. 5. As revealed in the plaintiff's motion to strike, 25, motion to strike, the defense counsel admitted to their client's guilt by not replying to any of the counts in their admittedly recognized and served amended complaint. Rule 8b-6. 6. Therefore, and it's demanding I put a comma, therefore the defense counsel, in pleading guilty for their client in a motion to dismiss with prejudice about a denied complaint, they were never served. Let's capitalize that. No, don't worry about it. Reveals the defense counsel is treating the court with contempt by delaying the eventual final order of judgment. 18 U.S.C. 1512 D1. I will not be reading those laws, but just understand that that's what the defense counsel is exposed of having committed. And the crime or the penalties for 1512s are 20 to 30 years, depending on which one it is. Except for the murder one, which they send you to other laws for those punishments. I obviously have not been murdered, so those don't apply, but the others do apply. Argument 2, In the 1st November 2019 hearing with Judge First and the plaintiff, Judge First denied the original complaint, but granted the plaintiff to amend the complaint after the plaintiff revealed to the court that the defendant had been paying Dr. Cohn, who was responsible for disappearing the plaintiff in his 2008 arrest. On 6 August 2019, the plaintiff served a petition for a redress of grievances with the Governor and Attorney General at the State of Utah Capitol and the Matheson Courthouse and to the administration building of the defendant at Temple Square. 2 weeks later, the State of Utah arrested the plaintiff, charged him with 3 counts of terroristic threat, referring to his complaint as a weapon of mass destruction. This information is contained in the amended complaint, and evidence will be listed, and I've got it on paper here to remember to also upload the evidence. But also I'm notifying the judge as well as counsel, who will be also receiving this, that these would have been listed on my evidence listing for the evidentiary hearing. Was ordered by Judge Treese to evaluate, if an evidentiary hearing would be held. Dr. Cohn was ordered by Judge Treese to evaluate the plaintiff for competency, which resulted in the plaintiff's disappearance for 6 years, as no trial was held for the plaintiff to defend himself, since he refused to plead to any other pleading but not guilty. And like I said in the other video, that also suggests that there's corruption in the system in Utah, but I don't go into it. Attached is evidence from Dr. Cohn's website before the 1st November 2019 hearing. That's part of what I need to remember to include. 9-minute entry, showing the defendant as a as the public advertising supporter of Dr. Cohn. 2. In the plaintiff's second motion for service, 11, second motion for service, which your honor has denied. 22, order denying. 11, second motion for service of process. Evidence was presented that the defendant stopped publicly advertising for Dr. Cohn after the 1 November 2019 hearing. Attached is the said evidence. This is going to get Judge Oberg in potential trouble, because she denied the motion that contained evidence in the case. Now, I would still include the evidence as if the case were to proceed to the evidentiary hearing and an eventual trial. But I'm setting it up for the final judgment motion, where I will be putting her on the interrogator's spotlight to let her know that she needs to choose America over the church if she wants to be honest and loyal to America, even if it may cost her her job. Three, in argument one, the conclusion established that the defense counsel, 1, had possession of the original unserved complaint, as their motion to dismiss was based upon it, 2, had knowledge of and had been served a copy of the amended complaint and pleaded guilty for their client, 3, were purposely delaying the inevitable order of judgment against their client, and the appearance of and timing of the defendant withdrawing public advertising to Dr. Cohn implicates the defense counsel in informing their client about the plaintiff's amended complaint, resulting in the tampering of evidence in the commission of a crime to cover up the payments being made to Dr. Cohn. 18 U.S.C. 1512C. 4. The defendant, after having been informed by legal counsel about their pending lawsuit by the plaintiff in concealing the illegally obtained payments to Dr. Cohn through the legitimate business of advertising, therefore also committed the crime of money laundering. 18 U.S.C. 1956, and it's the whole thing. You just can't do this, guys. This is not the true Church of Jesus Christ. He does not say any of this is acceptable in his Sermon on the Mount. He instead teaches me how to sue the church. 5. The defense counsel, being involved in these commissions of crime, of evidence tampering and money laundering, become equally guilty of the crimes committed by their client. That's guilt by association. They informed their client and obviously did not inform their client. You can't cover up, you can't tamper with evidence, you can't money launder. So they are responsible for the actions of their client in this matter. They get busted. That's why lawyers, whether defense or prosecution, will up and quit if they're honest to their loyalty to America, if they find out that there is criminal wrongdoing by their client, or as prosecutors in the case of the prosecution. As we've seen under Trump, many federal lawyers, prosecution lawyers, have up and quit when they were asked to violate their oath of loyalty to America. So argument 3. 1. After the plaintiff had served waiver of summons on the defense counsel on Friday, March 13th, 2020, the plaintiff received an eviction notice from his property manager, Samantha Hanson, referred to within the amended complaint. The notice claimed I acted as a racist to Percy James Pearson, also named in the amended complaint. The plaintiff is not a client of Percy's, as Percy has stayed away from the plaintiff for over a year by West Valley City Police orders. Despite Percy knowingly confronting the plaintiff and threatening the plaintiff's life and threatening to evict the plaintiff had recorded the incident, proving his innocence, which recording was known to Percy. Samantha was informed of the plaintiff's video evidence but refused further communication. The notice had not been acted on, Neither Percy nor Samantha have been terminated from their employment of their respective jobs, but the accusation still remains on the plaintiff's file with the property owners. You cannot commit crime when you're included in a lawsuit. This gets the church in trouble. This gets the lawyers in trouble as we get to it. 2. In the state of Utah, Governor Herbert had, by Friday the 13th of March, issued his stay home, stay safe for the national security pandemic threat. For the plaintiff to be evicted during a viral pandemic would have been a death sentence. We're leading up to the other charge in that tampering law. 3. It is established by the defense counsel that they admit the guilty plea of their client. In 2 weeks from this Friday the 13th incident, the defense counsel was expected to reply by their 30 March 2020 filing deadline. And I don't bring up that the judge had refused the entry of default. I could put that in there as a slam on the judge. I may reserve that for the final order for judgment. 4. The defense counsel has acknowledged being served with the amended complaint. The judge would also recognize this, that she had denied it. The defense counsel has acknowledged being served with the amended complaint and knew of its contents and all of those involved in the case. 5. The out of the ordinary appearance and timing of the actions by those listed in the amended complaint, which would have prevented the attendance, I'm using words from the law code, prevented the attendance and testimony with the attempted murder of the plaintiff in these proceedings, suggests direction through defense counsel. You cannot commit anything of a criminal nature while there is a trial going on, while there's a case pending. You have to be on your best behavior, and defense counsel must demand everybody as their clients to be on their best behavior. 18 USC 1512A 1 and 2. Conclusion. The defense counsel have been educated and received degrees in law, have passed the bar, have been licensed to practice law in the state of Utah, at least, have been hired by a law firm and assigned to this case. 15 and 16, notice of appearance. The plaintiff is merely an American citizen adhering to his First Amendment rights. As such, there is a higher bar and standard for counsel, either as prosecution or defense. And this is going to lead into the final judgment in regards to judges having a higher bar and standard set for them too. The conduct of the defense counsel is unbecoming, as they have held this court in contempt with their involvement in criminal activities to protect their client from the inevitable order of judgment against them. That's also a slam on the judges, but I will get to that in the next one. And that's it. And everything's all filled out with the correct dates, and there we go.